First of all, I'd like to thank you to the organizers for such an interesting conference with so many important topics. And for the beginning, it's always usual to pronounce my name and surname, but I'm coming from Croatia, and I usually starts with, I'm gonna make a short presentation, but it lasts sometimes longer than I initially wanted to present. Usually I don't have a typical lecture. I'm not ex-cathedra professor. Even I've been teaching at the School of Law last 20 years, and I've been concentrating on the issues of EU law and human rights perspective. So instead of giving ordinary lecture, I actually prepared questions to discuss. And there are 3 questions, and they're concentrated to the topic of this panel and related to the enlargement procedure in the area of Central and Eastern European countries, and maybe most specifically to the Western Balkan region. So the first question is why the negotiation process with the European Union took so long for all Central and Eastern European countries. Second, why the EU needs enlargement. And third, what benefits did Croatia get from the membership after 10 years? So these are 3 questions for discussion. So we're going to start with the first one, why the negotiation process with the European Union took so long for all Central and Eastern European countries. Well, actually everything starts from the Maastricht Treaty, and probably therefore we are discussing why the Maastricht Treaty is so relevant in the last 30 years. Since I'm a lawyer, I believe that the most challenging part is the legislative part of the accession procedure, even though from the economic perspective or political perspective, it could be considered as more difficult than the legal perspective. So from the point of the EU institutions, I believe that the European Commission is, of course, the most responsible one. And the European Commission, of course, started the procedure of negotiation in terms of acceding or accepting the acquis communautaire for all member states who joined the European Union in the last 30 years. So the negotiation process were extended through 35, well, actually more than 30 chapters. In Croatian case, that was 35 chapters, and the last one, indicatively, was the chapter on justice and fundamental rights. To my opinion, in Croatian case, that was the most difficult chapter. So why negotiation process were so long? Because in practice, since negotiation took place under the principle of the integrity of the acquis, that actually meant that only possible outcome of the negotiation process was the full application of the acquis communautaire by the new member states, and at the same time that were presided by overwhelming bargaining asymmetry between the European Union and the candidates. That latter lacking any credible capacity to threaten withdrawal in order to obtain a better agreement with candidate countries, and the talks could hardly be considered real negotiations. So from the historical point, you know that there was a special relationship between the Western and Eastern European countries after the fall of the Berlin Wall. And before that time, actually, I would say there was no relationship between Western and Eastern European countries. The relevance of value-based arguments to convert this initial policy into enlargement perspective actually started with Maastricht Treaty, which gave the basics for institutional reform in order to better functioning of the European Union, enlarged European Union, and of course the set of additional so-called Copenhagen criteria, from which the most important were, of course, political criteria. And the decision of the Luxembourg Council to start accession negotiations with all candidates at the same time was quite discutable, because some of the countries actually hadn't had fulfilled criteria in the requested time. So in all three instances, EU decisions also reflected an agreement on the right thing to do according to the common identity and shared values, rather than a balance of the material costs and benefits. From my point of perspective, considering enlargement stages, I would say that the most intensive part during the concluding European agreements and fulfilling all necessary requirements, including the politics of conditionality, I think that rule of law and respect for human rights were specifically difficult and challenging in the last 30 years. Why the European Union needs enlargement? This is my second question for discussion. In my opinion, that is because there is a need since Second World War to secure peace and stability in the whole Europe. The situation in the Western Balkans is complicated, and it's like keeping on and on going with same issues. And the third is to prove that it's dedicated not only to further development of internal market, but also to protect fundamental values, especially the rule of law. Then to prove that the European Union is dedicated to protect basic fundamental rights, to further promote the motto united in diversity, and of course to bring every European, so not EU, but every European citizen closer to the Union. So the basic fundamental values, the EU fundamental values, are democracy, human rights, and the rule of law, as it's written in the Article 2 of the Treaty on the European Union. In the period before the accession, candidate countries were very active in harmonizing the law and policies. I call it, not only me, but other lawyers, positive normativism. But after the accession, the reforms slowed down, and the whole process is, at least in my opinion, considering Croatian situation, in stagnation, and in some cases situation is even worse in terms of protection of human rights. And I believe that is because before the accession period there was a quite intensive EU monitoring mechanism, and after the accession there was no monitoring mechanism, except of Bulgaria and Romania. There was a special mechanism in terms of corruption and organized crime. So before the accession we had active fulfillment of negotiation chapters, and afterwards, let's say, stagnation and rule of law backsliding. So let's focus a bit more on Croatia, since I come from Croatia. Croatia joined the European Union 10 years ago, in July the 1st. So today is, well, tomorrow is the 1st of July. So tomorrow is the 10th Croatian anniversary. And there are 12 years after signing the Stabilization and Association Agreement, which entered in Croatia into force in 2004. Just for the point of comparison, Macedonia was the first country which signed the Stabilization and Association Agreement, so a couple of months before Croatia, and Croatia is the member states and Macedonia is not. North Macedonia, excuse me. Yeah. I said Slovenia. Oh, I apologize. Since this year, So the 1st of January 2023, Croatia is also became a member of Schengen zone and Eurozone, and everything looks nice if we consider the period after the accession and considering the fact that we are the members of the Eurozone, Schengen zone, and of course the European Union. There have been too many obstacles on the path towards the European Union membership, and of course the most significant were of political nature, especially considering the point that Croatia started the accession negotiations on 3rd of October 2005. So challenges before the membership for Croatia. Well, one of them is that Croatia started negotiations together with Turkey, which made Croatia's part more difficult. Then cooperation with Hague Court in terms of war crimes, situation with the border with Slovenia took Croatia approximately 4 years in the negotiation process. And again, significantly, Croatia finished the negotiations on the last day of the Hungarian presidency. So thanks to Hungary, Croatia finished negotiations. Other challenges after the membership: need for further economic development, rule of law. This is, to me, maybe the most relevant part, because according to, I would say, soft law mechanism of the European Commission, the third rule of law report and in the part for Croatia, there are still some obstacles in appointment of judges, inconsistency of the national court's case law, lack of transparency in publishing court decisions, citizens' distrust in judiciary, still long court trials, violation of the Article 6 of the European Convention on Human Rights, increased number of lawsuits against journalists, challenges in following recommendations of the independent equality bodies, deficiency in the system of free legal aid. And maybe the third most challenging part is human rights protection. According to Croatian ombudsperson for human rights, there is a persistent discrimination against Roma people and Serb national minority, and there is a growing hate speech in media against, again, Roma people and Serb national minority. 7 years ago, Croatia was, in economic sense, at 59% of the development of the European Union, and today is at 73, which is a quite good score. Regarding the EU funds, Croatia has a surplus of more than 10.7 billion euros, which is again a quite good score. As a lawyer, I would say there is a complete harmonization with the acquis communautaire, with some small exceptions, but I don't want to mention that. The good and positive thing is that opening of the office of the European Public Prosecutor, of the Office of the Public Prosecutor in Zagreb proved to be complete success, at least when it comes to embezzlement of European money. There is a new law on whistleblowers. Ombudsperson for Human Rights is constantly receiving complaints. There is a new anti-corruption strategy. Significantly, Croatian civil society, immediately after Croatia joined the European Union, divided into left and right. Just a few weeks before Croatia entry to the European Union, for instance, there is one interesting example. The association in the name of the family was registered, which officially started so-called conservative revolution. In the meantime, referendum took place, which made marriage a constitutional category reserved exclusively for women and men. Maybe, well, in an economic sense, last but not least, a large part of Croatian citizens who expected a better life, which was realized for them only in terms of mobility of workers and students. So a large number of Croatian citizens went to the Western European countries in order to get better life. So, dilemmas. Enlargement is a bit of collective action dilemma. Member states know that enlargement is good for them collectively over the long term, but individually damaging in the short term, in both institutional and economic terms, and member states should overcome this collective action dilemma in order to optimize enlargement. I think, and this is something I would point as a concluding remarks or introduction into maybe the further panel. I think that there should be a positive perspective for all candidates for the future membership, but more specifically I would put emphasis on the positive perspective for the Western Balkans, because from the perspective of Croatia I think that it would be the best political, economical decision and even legal for the countries of the Western Balkan to join the European Union as soon as possible. But there is one problematic thing in that respect. The countries created by the breakup of Yugoslavia, it's even evident today, they prefer to look at differences between themselves instead of trying to look and get more similarities together to connect them. And that's basically it. I think I finished just on time.